Hi, Bhavan, and welcome to Maxwell's Business Owl program. I have done a few videos on business-related matters on the Business Owl program in Singular. We refer to Owl as wisdom, and we are referring here, interpreting this name Owl as the wisdom business. I produced a video and published a video for startups, branding for startups. On this particular video, I have described the basic elements of a brand. Brand should be pronounceable. Brand should be memorable. Brand should not have a conflict with existing brands. And finally, a brand should also be able to be registered under the intellectual property code if you really want to register as a trademark. So on the previous video, I have described them all in detail, but the legal side I have not described in detail. Therefore, I thought of producing another video and publishing for the benefit of my viewers. And also, I thought of producing this in English, as it could be used by a person from another country who comes to register his or his company's brand name in Sri Lanka as a trademark. So let me share a video, let me share a PowerPoint presentation so that I would be able to go by step on to the subject. This is called an introduction to law relating to trademarks and service marks in Sri Lanka. So therefore, I must confess that this is not an exhaustive presentation, but it would give you a basic idea. The trademarks and the service marks are governed in Sri Lanka by Intellectual Property Act. So definition of trademarks and service marks could be described as this: a trademark or a service mark is any visible sign serving to distinguish the goods or services of one enterprise from those of those goods or services of other enterprises. So the most important word here is serving. The brand name or the trademark is serving to distinguish the goods or services from another enterprise. Service mark is any visible sign to distinguish these the services of one enterprise from those of other enterprise, as I described. Sorry, it has been repeated here. Trademarks are attached to products, and service marks are attached to services. Assume if you are having a coffee, you have a coffee brand called Harishchan, so it's a product. If you're having an airline and you have an airline service mark as Sri Lanka, so it's a service mark. Other than that, there is no practical difference in both these marks. Same principles of law are applicable for trademarks as well as service marks in Sri Lanka. Function of a trademark or a service mark: it serves to distinguish goods or services of different enterprises. The most important element of the service mark or trademark is that it indicates the source and quality of goods and services to the consumer. It enables the owners to individualize the mark and promote the product to consumers. It allows the owner to improve the quality of the product bearing his own mark to have an advantage over the competitive products. Trademarks significantly assist consumers to make their choices as well. So once you register a trademark, you get an exclusive right to that mark. On proper registration, one will get an exclusive right to use the mark. The law does not make registration compulsory. You can have any trademark or brand, any brand. There is no law that the law says that you need to register your brand name. Even a non-registered mark may seek legal redress under other laws, such as unfair competition, under common law passing off, if his rights are infringed. So therefore, there is no compulsion in law that you should register a brand name. But if you register a brand name, you get more protection and more legal protection under the IPA. So therefore, it is always better if you could register your brand name as a trademark. So what constitutes a mark? As per the section 102, subsection 3 of the IPA code, any visible sign capable of distinguishing goods or services of different enterprise can generally constitute a lawful mark. Mark may consist of many elements. It could be arbitrary or fanciful designation, names, geographical names, slogans, devices, letters, numbers, labels, or combination of any of those. If you just see some of the brand names in the world, all these brands have different designs, fanciful designs, different names. Some are coin names, some names are just letters like BBC, CNN, and IBM. So there are other names like there are just symbols like when you say Nike, the swoosh is just a symbol, and Toyota has a logo plus a symbol. So Pepsi has a fanciful design and also its name. So Puma is having a leopard kind of animal, probably there's an animal called Puma, I think. So this is how it is. So you can have any of those in the brand names, and those brand names can be registered as trademarks. Admissibility of a mark in Sri Lanka. Mark is admissible if it is not inadmissible under section 103 and 104 of the IPA code. So section 103 and 104 says what are the brands that cannot be registered. In other words, inadmissible as a brand, as a trademark. So under 103, 103 talks about objective grounds, shapes and forms imposed by inherent nature. So we need to go into case law in order to give interpretations to this. But just for, on my opinion, I think if you are selling caps and if you want to register your cap trademark, you may not be given head as the trademark because it's the inherent nature where you wear this particular product. So all others could be able to use that element if they really want to show in a photograph or wear it on a model or whatever. So therefore, the imposed by inherent nature certain forms you may not be able to register as a brand as your trademark. Descriptiveness is the mark resembles signs or indication which may in the ordinary trade or life designate the kind, quality, purpose, value, place of origin, time of production or supply of goods. Again, we need to go into case law to find this. But just an example, in Sri Lanka we use mikiri, curd. We always talk about Rune mikiri. Everyone talks about it. So it has become the place of origin is referred always there. So therefore, one may not be able to register Rune mikiri as his own brand name or the trade name, trademark. So he can just say that the Rune mikiri in the description, but he may not be able to get his trademark as Rune mikiri, probably the obvious reason that all other curd users or the traders or the vendors, manufacturers should be able to use that word freely. Generic signs or indications. If a mark resembles a sign that has become in current language or established trade in Sri Lanka, a customary designation for goods, then it cannot be given as an exclusive trademark. The test here is it has evolved in the society and evolved in the business practices a name for that. So therefore, that name is not yours. That name is common. So anybody should be able to use. If I want to give you a simple example, in Sri Lanka, all soft drinks sold by roadside vendors on pavements are generally called sarvat. So we call them as sarvat. So one may not be able to register sarvat as his or her trademark under this provision, as because everyone refers to that as sarvat, this particular product on the roadside. So therefore, if you want to take, once you register a trademark, you get the exclusive right. The test is, if you want to get exclusive right, you must find a word exclusive. That's the best way. So therefore, if you go on those lines, a common name that has evolved, common name that has been used, may not be the best name that a person could get. Marks incapable of distinguishing goods or services. A mark should always have a distinctive character. If not, it cannot serve as a mode of distinguishing the goods or services of different enterprise. So therefore, you need to have your own mark, as I told you earlier as well. So if you have a fine word, if you can invent a word, that will be the best, because that is unique. You have invented that word. So if you can use a word that you could use, a new word, it is definitely you would be able to register because it's yours, right? So once you get a trademark, it is going to be yours exclusive. So you cannot have someone else's or something that is existing as exclusively of yours. That's the test. So immoral or scandalous or antisocial marks are also not given in Sri Lanka. So immoral, scandalous, antisocial depends on the value system of a society, its culture. So therefore, these things could change from one country to another country. Something that could be registered in some other country may not be able to register in Sri Lanka. So there are scandalous designs contrary to morality, offered racial or religious susceptibilities. Now, say for instance, there was an instance in India that someone wanted to register a bag of sambar rice as Gandhism. It's not given. A cross or a Buddha's image may not be given as a brand name or a trademark. A sign or image considered by general society as vulgar. There are so many images or symbols that we use as vulgar, so that cannot be even registered as a trademark. Now, if you say now there is something called brand name called FCUK Hill and also FCUK brand name of French connection in UK. This could be pronounced in different format. So therefore, these kind of things may not be able to register in Sri Lanka unless this company, as we have come into an international agreement that the registered names in other countries are also respected and protected here. So I have found also now, say for instance, certain countries have bars called Buddha bar, where alcohol is served and rock bands are playing. But I don't think that that kind of a trademark could be registered in Sri Lanka according to the Sri Lanka's cultural and moral standards that we have. So therefore, even a foreigner comes to register some brands that would have been registered in their own country, it may not be able to register in Sri Lanka. Under this section, misleading marks. Marks will not be registered if it is likely to mislead the public or the trade as to the nature, source, manufacturing process, characteristics, suitability for the purpose of goods services concerned. Say for instance, in my opinion, if someone is producing artificial soft drinks, say artificial mango drink, totally artificial, he may not be able to get a trademark as a natural mango. Natural mango cannot be used as a trademark because it really misleads the process and also the nature and the production of the process, because no mangoes are used in order to produce this, but you are using a mango as a trademark. So that is not probably allowed. These are you need to go into case law for these, but this is my opinion. Names of individuals and enterprises. Names can be registered subject to certain rules, but it should be a name of an actual person, living or an existing organization. If a name to be registered as a trademark, it should be special and particular manner where it could serve as a mark of distinction. So your name is written in a special way, then you could register that as your own brand. But it's not the general fonts that you write your name, general fonts that are used usual. So therefore, simply printed, typewritten in the ordinary hand, or just written in the ordinary hand, may not be treated as a special or particular manner. Surnames alone cannot be registered generally. Therefore, name here denotes the whole name. If you really want, you need to have the whole name. Maxwell Ranasinghe. So probably I can register my trademark as a Maxwell Ranasinghe, but I cannot write in the normal format, normal fonts that is available. I'll find a special way of writing, which is not common, so that it is going to be unique. So I'll show you now. It's here again. Now it has been used in this particular form. Emporio Armani, Pierre Cardin, Harish Chandra, Jinadasagi Balaguli, and all these things are specifically written with some kind of logo or some kind of artistic format. So therefore, if you want to write, if you want to have a name, it should not only come as simple name. You should get the whole name, or it should come out with some design. So that is given. So Harish Chandra is not purely Harish Chandra is not given, but Harish Chandra as a trademark comes with this logo and the symbol. So therefore, you can mix it with your name and another one, so it becomes unique for you. So here again, the uniqueness that would distinguish other products from your product is the most important test here in branding registration of brands as a trademark. And also, geographical names and surnames are also not given under the IPA. Generally, according to ordinary significance, the normal understanding, the geographical name or surname is not allowed to be registered as a trademark because it is a common thing again. It should be available for everybody. So therefore, it is not usually given as a trademark. However, it can be proved that name or place is of significance for the trade to distinguish the product. It should be possible to register with some form of artistic manner, coupled with some design. So if you take Gampa Vikramarajah with the tracks, it has been, if you prove that the name and the place is very important, it could get the permission to register. And Sri Lankan is Sri Lanka, but Sri Lankan airline is using Sri Lankan as a trademark. So that there again, you'll have to prove that it is important in national airline carrier, and therefore it's important to use that. So that kind of argument should be there. Now, if you say that Vikampa Vikramarajah, this is the symbol and the logo and the trademark, so they're using it together with certain artistic logos and a label. Even Sri Lankan is using this kind of a logo, not only just Sri Lankan, but with their logo. So that is how it is coming to play as a brand name being registered as a trademark. So there is some exclusivity into the design. Admissibility of marks under section 104. This section deals with marks inadmissible mainly due to third-party rights. The first one is the mark which is likely to misleading resemblance to other lawfully filed or registered marks. There are so many. This is the common issue that most of us face, because so many brands are coming similar to famous brands. So these are really misleading. Therefore, in order to protect the consumer and also to protect the owner of the original brand name, and also to have the exclusivity and uniqueness, so the brands are not given if there is some kind of a resemblance to another brand. Now, if you see that the Nokia is a famous brand, but if anybody comes with Nokia, probably it is not given for the same product. And there is something called Hugo Boss. So this is something, the same fonts are used, but in a different form. This also may not be given. Now we have a famous brand called Puma, but this is just a jumble of the words. This also may not be given in under the IPA. McDonald kind of logo will not be given in the restaurant business. And also Sony, the original Sony is on top, and the next one is someone is producing batteries under that. There is no O after S, but it looks like Sony. It's difficult to pronounce other than Sony, but it's there in the batteries. So all these things may not be, this simple examples that I would like to show you, may not be able to register as a logo trademark. So the another one, Nike as Nike, it also may not be given. This is a red bottle to red label, looks the same, so it could resemble the original red label. So a mark that resembles in such a way as to be likely to mislead the public, maybe collective mark, certification mark whose registration has expired, not been renewed during the 2 years preceding the filing of the application for the registration mark in question, may also not be given. That is, renunciation or removal or nullity has been recorded in the register for the 2-year period. The filing of an application for that kind of a mark is not given. So this has been there again. This mark was there in the past and it has been nullified, but still it may not be given within the 2-year period preceding the nullity. A mark shall not be registered in relation to goods or services which are prohibited in Sri Lanka. Assume there are certain products prohibited in Sri Lanka. Say in Sri Lanka, trade cannabis is prohibited, but it could be legal in a country like Canada. So assume the Canadian company comes and try to register their own cannabis brand here in Sri Lanka. It may not be able to get registered because cannabis is not a legal product in Sri Lanka. Just a simple example. And also when a mark consists of a certain word or definition such as president, prime minister, minister, state, government, or any other similar word or term that is likely to mislead the public into believing that such mark has state patronage or authorization, such marks are not admissible. If you're trying to show that you are part of the state, this product comes from state, and you're using all these names, if you are using some of the names or something that may be interpreted, you may not be given that particular name as a trademark. So importance of registration, again, registering a trademark gives the owner an exclusive right. We have discussed this. Most importantly, registration makes it easier to take legal action to prevent others from using a mark. That is the most important aspect of registering a brand as a trade mark. Registration alone is not enough, but trader must actively use the mark in the course of trade. If not, that can be removed from the grounds of non-use. So you register a mark and use it, then you become an owner, you become the active owner of that product. If you just leave it without doing anything, then it will be removed under the grounds of non-use. So any product, any trademark that you register should be used once you have registered. The registration process is very important. there are firms that will undertake registration, or else you could do on your own if you can go through the procedure. So trademarks, patents, industrial designs have to be registered as per the IPA. Once the application is filed, the trademark, patent or industrial design will be gazetted. Objections can be made within 3 months. Any other person who is objecting, he would be able to make his own objections within 3 months. It's to the Director General of Intellectual Property. If no objections are made, it may be registered. If objections are not made but found later by the original owner that there is the new trademark has been registered, still he could go to court for nullity. So it's going to be a court process. If you are not objected within the 3 months period, later on he comes to know. Still he has a right to go to court. So the duration of a trademark is in Sri Lanka, it's once you register a trademark, you can go up to 10 years. On the expiration of the period, that is 10 years, it could be renewed for further period of 10 years. So this is a general understanding or an introduction to the trademark law in Sri Lanka. As I told you initially, we're not a comprehensive presentation on the subject. The trademark law is a specialized field of law. There are a number of books published on this subject. Specifically to Sri Lanka, there is a book, A Guide to Law of Trademarks and Service Marks in Sri Lanka by Dr. B. Karunaratne. And there are many other books as well, which are relating to trademark law. So you need to write, you need to read and understand the basics if you can go details. But simply, as I explained you, you would be able to understand this by going through my video, and also you can start your own application if it is not a complicated one. If you don't make it complicated, then only you have issues. So further, there are several law firms that offer services on trademarks and trademark related law and the way it works and registration, and also if your rights have been infringed, you would be able to consult them even to litigate. So I think I have given you a basic understanding of law relating to trademarks or service marks in Sri Lanka. So you would follow the law and do the correct thing rather than getting into issues that businessmen don't want to. Because businesses don't want to go into court and get involved in legal battles. They want to do business. So if you have wisdom, you go through the simple processes that I have explained here, as well as in my branding lecture, so that you would be able to get an idea of how to name a brand and how to register that brand name as a trademark. Thank you so much. Good luck with your business.